I'll never forget, I had this one cost assessment, and I came in with, I don't know, 25 hours, and the other side said, well, I only spent 15. And I said, Your Honor, I won, he lost. Maybe if he spent 10 more hours, he would have won too.
Welcome to Water Cooler Justice. I'm Chris Robertson. I've been practicing employment law for over 20 years, helping clients resolve disputes and navigate challenges at work.
And I'm Sarah Goodenough, Chris's legal assistant.
Today's discussion is about Dufault v. the Township of Ignace, and it's a great continuation of our last discussion about just cause, because we'll look at those words again in a different context. Our panelists today are excellent, Barry Fisher and Stuart Rudner. Welcome back. If you haven't listened to episode 3 about Just Cause, you should check that out. We know Barry here is the Dean of Employment Law. His blog is a must-read for anyone practicing or interested in employment law. He's a mediator and an arbitrator in Toronto and brings over 30 years of experience as an employment lawyer and legal author to our show today. Thank you for joining us again, Barry.
My pleasure.
Stuart Rudner is the managing partner. That didn't sound like a pleasure, Barry. It sounded like, you're here under duress, man.
That's as happy as he gets.
I've been up since 7 in the morning, so whatever.
All right. Stuart Rudner is the managing partner at Rudner Law. As a trained mediator and expert in alternative dispute resolution, he approaches employment matters with neutrality, aiming to achieve fair outcomes for all parties involved. He's also the author of the book, You're Fired! Just Cause for Dismissal in Canada. Welcome back.
Was Trump your co-author on that, Stuart?
It was long before the Trump days.
Sure.
I love the way you said that, Chris. I might have to hire you to record that.
I just think it's fun, right? Like, I've never actually got to say it to anybody, so there you go.
There's always Sarah you can say it to,
Never gonna happen, Barry. Never gonna happen.
Chris, you should never say that when it's being recorded.
I would back up the Brinks truck before I
she may fire you first, so who knows?
Yeah, that's probably how it'll go. But, they say a good mentor doesn't hope that you'll leave. They know that you will.
All right.
So there you go. Sarah, let's take our listeners through details of today's case. I think I paraphrased Ted Lasso there. Just, full disclosure and copyright breach and all those good.
Wow. So we've worked in Trump and Ted Lasso in the first 5 minutes. I love it.
It's going to be the best podcast thus far. Okay, so let's dive into this here. So our story has 3 acts. So act number 1 is going to be the lower court case, which is the original trial decision. Act 2 will discuss the reasons for the costs, and then Act number 3 is the Ontario Court of Appeal decision. So let's start with Act number 1, the lower court case. Here's a couple things that you need to know. So Karen Dufault, the plaintiff, commenced her employment with the Township of Ignace on October 31st, 2021. In January of 2022, she accepted a new role as Youth Engagement Coordinator, where she earned about $75,000 per year plus benefits. And at the end of November 2022, Karen then signed a fixed-term agreement with the defendant, wherein it was agreed that Karen's employment would be continued for a fixed duration, ending on December 31st, 2024. About 2 months later, at the end of January of 2023, the plaintiff's employment was terminated effective immediately on a without cause basis. Upon terminating Karen's employment, the defendant paid her just 2 weeks of termination pay in the amount of $2,884. They continued her benefits for 2 weeks. However, her pension plan was terminated effective immediately. Karen pleads that the termination clause is illegal and therefore unenforceable, and sought damages in the amount of 101 weeks of base salary inclusive of benefits, but less damages already paid, for a total award of just over $157,000. The defendant submits that the wording of the contract is clear and that the plaintiff has been paid the damage to which she is entitled under the ESA Act.
Yeah, so the main event in this case was the cause without cause, which is the subject of another set of decisions, Waksdale, which went to the Court of Appeal. But there were additional attacks, including an attack on the termination provision for containing the phrase "at any time." And so, I think that's an interesting one or a good place to start our discussion. I've certainly seen that phrase at any time in management rights provisions and collective agreements, but it looks like it doesn't belong in termination provisions. And I thought, I'd like to hear what you guys had to say about that particular tack because it's novel. And also, just as a general rule, the drafting of provisions or ESA termination provisions. Do you want to start us off, Barry, maybe?
Sure. The reason the at any time was held to be, well, first of all, it's completely unnecessary. It adds absolutely nothing. It would mean the same thing if they didn't put it in. So probably some lawyer 40 years ago wrote it in and everybody copies it. But what the court found was defective about it was you can't fire someone at any time. Now, to be fair, it says at any time in their sole discretion too. There are many occasions where you cannot fire someone. You cannot fire someone because they're on an authorized leave. You may not be able to fire someone on an authorized leave of absence, maternity leave, paternity leave, bereavement leave. There's 1,000 leaves under the Act. Secondly, you can't fire someone in reprisal of them pursuing their rights under various statutes, human rights, employment standards. So there's a number of occasions where you simply cannot fire somebody for any reason whatsoever. And that was a major focus. And this at any time or sole discretion at any time it's found in many, many agreements, again, probably because somebody copied it from 40 years ago. There were other ones too. They referred to base salary. That's not correct either because the Act talks about wages, and wages include base salary, commissions. He says vacation pay. I think he's wrong about that part. But anyway, so there's a number. You could drive a truck through this clause. It's remarkable. The real reason the township is so upset because they stupidly entered into a fixed-term contract. There's almost no valid reason why any employer should ever enter into a fixed-term contract. It's the worst, and in Ontario, it's the worst combination because you get the balance of the contract not subject to mitigation. This woman could have been fired on Monday, get her $101,000, I think it was, or something. I can't remember, 101 weeks. And she could start a new job at a higher rate and still get it. Now, that's only in Ontario. In BC, you can't do that. So there's almost no valid, the lesson to learn from an employer from this thing is you never need a fixed term contract. What you need is an enforceable termination clause.
Which is often easier said than done.
Yeah,
Pardon?
Stuart, do you want to tell us, can you give me some thoughts from, a management side practice? I know you have both employees and management clients.
Yeah, I do see both sides. And look, I agree with everything Barry said. I mean, I think in this case never should have gone to trial because, putting aside the novel arguments they made, it was a clear Waksdale issue and the contract was not enforceable. But the whole at any time clause, I want to focus on that because I see that in probably the majority of contracts I review. And 3 years ago, if someone put that clause in front of you and asked you about it, I think we all would have just glossed over and said, yeah, looks fine. We never would have thought twice about that wording. And I give plaintiff counsel credit for being creative here and making the argument. And as Barry explained, it's technically correct. To me, I just think it's totally unnecessary. I don't think the court had to deal with the issue, but they did. Court of Appeal chose not to because they didn't have to. But I think one good thing that might come out of this is I can tell you that my team sat down and had a really fun dinner reviewing our termination clauses, which lasted through dinner and dessert and drinks and much, much longer. But the good news is our termination clauses over the years have been getting longer and longer and longer. And now what I said was, look, let's just cut out any extraneous language. We don't need to say it any time. Take it out. We don't need to say at your discretion. Take it out. And our termination clause is now a lot shorter than it has been in years. So maybe that's one positive thing to take out of this. The only other thing I would say is, I'm still dealing with this both as counsel and when I'm mediating. And employer counsel, they all hate this case, and I don't necessarily blame them. But a lot of them are just burying their heads in the sand and saying, well, it's a stupid decision, so we're not really going to take it into account. And stupid or not, it is the law. So I think they're really, their clients are coming in and they're being fed this information from their lawyers saying, well, it's just a dumb decision. So they're thinking they don't have risk. And when I've sat down with employers, they realize, wait a minute, there is a real risk here. This is, as Barry said, the worst possible scenario. But it is currently a very easy way to attack a whole lot of contracts that, even if they weren't, in breach of Waksdale, they're now offside.
Yeah, I mean, so I agree with you. So my termination provision has been down to about 2 sentences for a long time, if I can get the employer to agree. What I've noticed is that I give, if for example I've drafted a contract for a large employer, they come back to me 5 or 10 years later, and the termination provision looks very different than the one I sent them 5 or 10 years ago. And what's ended up happening is they've had resolutions, they've had outcomes. They've had negotiations, and they've decided, we're not doing that again. And so they've, tried to sort of part with or parse or cut away. Usually it's elements of compensation, bonus, or benefits, right? And again,
bonuses,
the problem,
they hate paying bonuses over there.
it's incentive pay. It's actually supposed to, short-term incentive is specifically to incentivize an employee to perform well in the near term. Right? And so paying somebody an incentive when you know that they're not providing any service, I can understand why employers would get frustrated with that, but that's not what the ESA provides for. And if you draft that carve out in a way that offends the ESA, your whole provision fails. And that's, for me, that's what's fascinating for me is a tiny mistake. So as you said, Stuart, a phrase at any time, something that many people would gloss over in the past, right, is suddenly, fatal, not just, it's fatal in a way that triggers a huge liability. In this case, because it was a fixed term contract, $100,000 versus $2,884. Like, I can see why they called their lawyer. It's unfortunate, though. I agree with Barry. I don't think that, and Stuart, I don't think this should have ever gone to trial. It had obvious hurdles to overcome. It appears that, they took it to trial simply because the difference between the parties, the delta between the parties was so great that even if there was a low chance of success, the cost was worth it, right? In the same way that, a hockey team will challenge a late third period goal, even though, it probably isn't going to survive any kind of review.
Those reviews are even less predictable than our court's treatment of termination clauses.
Right, but I get why you might do it. Yeah. Ultimately, the outcome here though was predictable, and I think maybe better than an NHL video review. They took this thing to trial, and it did not survive judicial scrutiny.
Went to the Court of Appeal, and they're seeking leave to the Supreme Court of Canada.
Well, we're going to get to that. That's Act 2 and Act 3, Barry. Don't skip ahead, man.
Oh, no, she didn't say it's Act 4. I'm trying
to end Act 1 so that there's a cliffhanger, and then people want to hang around, and then they're binging the whole thing, right? All right, here we go. So, Sarah, why don't you take over from here?
Perfect. Okay, so we'll have to save Act 4 for a subsequent podcast, it sounds like. But let's jump into Act 2, which is the cost. So the cost summary judgment motions happen when the court decides who should pay legal costs based on whether the motion was successful, fair, and reasonable. Now, Karen was awarded just over $157,000 on a summary judgment motion and now seeks her cost of $25,358. So it's important to note a couple of things. Number one, Karen made a Rule 49 offer for $120,000 early on. Since the final award was higher, she is asking for higher costs recovery pursuant to Rule 49. Number two, the defendant failed to make a settlement offer, and they also refused mediation, which the court may also consider when deciding costs. And consequently, Karen is entitled to higher costs, but the court must decide what's a reasonable amount based on the following information. So whether the case was in simple procedure, the fact that Karen's lawyer's bill was billed over 57 hours, while the defendant's lawyer only billed 17 hours. And Karen also billed time for a case conference that could have been avoided. So the defendant has argued that Karen's lawyer fees are too high in comparison to the defendant's lawyer rates. Now, ultimately, the court decided that Karen's legal bill was excessive and ordered the defendant to pay $6,500 in costs within 30 days. So what are your thoughts on the cost decision here?
Well, so I think everybody's going to have lots to say here. I think $6,500 for a summary judgment motion in Toronto seems a bit on the low side, and she did have Toronto counsel. So, Barry, I mean, why don't you, I know you've looked at a lot of cost awards and you've written some stuff about cost awards and employment matters on your blog. Why don't you start us off again here?
It's outrageous. I mean, from a practical point of view, I think the judge realized how much the township was going to pay in the judgment, so he just reduced it. But the analysis is completely off the mark. First of all, $6,500. The typical, I did a study of this years ago, and the typical cost award for, and this was literally years ago, because like 5 years ago, the typical cost award for a motion for summary judgment was in excess of $25,000. He made so many mistakes in the cost award; it's unbelievable. I love the part where he says the plaintiff spent more time than the defendant. When I used to practice and I won a case, I'll never forget. I had this one cost assessment, and I came in with 25 hours, and the other side said, "Well, I only spent 15," and I said, "Your Honor, I won. He lost." Maybe if he spent 10 more hours, he would have won too. So
I know you could have spent 100 hours on this thing, and they were.
Yeah,
still
no, I know, but
but
it's just like oh well, the loser spent less time, so he shouldn't. And then, and when you read the case, he talks about the Thunder Bay lawyer saying, "Well, I only charge $297 an hour." I mean, paralegals get $297 an hour. It's ridiculous. So, he got $15,000 for the Court of Appeal. It's a joke, but I think probably judges he think, oh well, the township has really been hit with a lot of money, so it's so ridiculously low that. But I guess to me that was the trade-off, and they're not going to bother cross-appealing on that.
Leaving aside that it was a summary judgment, imagine, for example, they'd had a 2-day trial. Stuart, what would you have expected a cost award for a 2-day trial to look like on a wrongful dismissal like this?
Probably would have been in a similar range to what Barry's talking about, in that $25,000 or $30,000 range. But I think, and look, I agree with what Barry's saying, and it probably was the judge trying to soften the blow for the township. But it's also a great example of what we always say, that trials are just so inherently unpredictable. In this case, it wasn't even the decision; it was the costs award. And in this case, we would probably say she'd done everything right. She made an offer, she beat the offer. They didn't make an offer. Everything seemed to be lining up, so she's going to be getting more than the typical award. And yet somehow she ends up getting roughly 25% of what she was seeking. So, we have this conversation all the time with our clients that you can go to trial. First of all, as we always say, it's going to take forever to get there. It's going to cost a fortune to get there. But we also always emphasize you just don't know what's going to happen. It does depend on which judge you get. So this is a perfect example of that, where, yeah, she won and she got a great payout. But if she was also, as counsel will always say to me in mediation, well, if we don't sell today, we're going to make a Rule 49 offer and we're going to beat the offer. And they did. And it still didn't even pay out. So she still ended up paying, I don't know what her total legal bill was, but she spent a whole lot of money and
Probably a contingency fee anyway. So.
I've heard different civil litigators use different ratios, but you often hear 20%, 25%, a quarter, a third of the value of the claim is the likely cost to take the matter through to the end of trial, right? Because the more the claim is worth, the more fighting there will be, the more, typically the more complex the matter is, the more documents there may be. And so, I think that's interesting. But in employment matters, that's just not true for plaintiff side, right? On the plaintiff side, the documents are the same, whether you're a senior executive or whether you're, a relatively junior employee. With the exception of plans, right? If you're looking at executive compensation plans, those can be quite detailed and they can be quite long. But as a general rule, it's kind of the same stuff, whether it's $1 million or whether it's $100,000. I'm surprised at how much the cost awards vary, right? And so, to your point, maybe you're right. Maybe it's the judge, trying to do some justice here. But because I think that the original summary judgment motion was so ill-conceived, and because she had done everything correctly under the rules to maximize her chance of the cost award, this one for me is a bit weird. You have a summary judgment motion, which should result in the outcome that it did result in, the award of the remainder of the value of the fixed term contract. But then the costs award is completely random. And so, Stuart, I take your point on that. Wow, right? Like there's just anything where you've got to get in front of a judge is just inherently there's risk of unexpected outcome. All right, Sarah, let's do Act 3.
Okay, great. So Act number 3 is our appeal. So the town of Ignace appealed the trial decision, and they're asking the court for a couple of things. They want the court to reconsider the past decision of the Waksdale case, in which the judge ruled that the termination provision of an employment agreement must be read as a whole. Therefore, if one termination provision is deemed illegal for failing to meet the ESA, the entire provision is considered void. And the second is to allow part of the contract to remain valid, specifically the without cause provision. So I'd like to hear your thoughts on Waksdale, and do you think the court's decision was too strict in this case?
Yeah, when I saw this in the script, Chris and Sarah, I was thinking about this. I've kind of gone back and forth, but I do think Waksdale is just too far. And as you've said, in my practice, I work with employers, employees, I mediate, so I'm not, inherently of one ideology or the other, but we've seen this, and Barry, you've been practicing longer than I have. We've seen the courts go back and forth between employees and employers, but they are farther now on the employee side than I've ever seen them. And I actually thought, and I think it was around 2018, there was a case with IBM. I think it was Amberber and IBM. And I thought that was a signal we were going to start shifting more towards the employer side and what I thought was more of a common sense approach, because I'm paraphrasing the Court of Appeal. But basically what they said was courts should not be straining to find ambiguity where it doesn't exist. I love that quote. I kind of take the similar approach. I think they shouldn't be straining to find these hypothetical breaches of the legislation where it doesn't really exist. So I fully agree. If a company puts a clause in that says, if we're going to let you go without cause, we can give you 2 weeks and that's it. That's offside, and they shouldn't. I know the courts don't want companies to try that. And then the penalty, if they fail, is, well, then you got to do what you should have done to begin with. So I understand that. But, a bunch of the cases culminating in Waksdale, they're just finding these hypothetical possible breaches that are so beyond the pale that I don't know why, if you have a perfectly valid without cause section, I don't think your with cause section that could conceivably, possibly, maybe be a breach should invalidate the whole thing. So I do think that it's gone too far. Now, that being said, I'm not on the bench, and I'm certainly not the Court of Appeal, so the law is what it is. But I do agree with a lot of our colleagues who think it's gone too far.
Well, so I don't know about a lot of our colleagues, but what I will say is this. When I first started, there was no Waksdale, right? So it was not as simple as that. You had to really sort of parse out the ESA. You had to look at, definitions in the act like regular wages or, base salary would appear in the provision. You had to work for it a little bit, right? Now, Barry, you've been doing this for a long time. Do you think that the trend has gone too far? Do you think that the statute could be clearer? What are your thoughts?
Well, I don't think they've gone too far. The concern I always have is you go back to Mactinger, the original decision of the Supreme Court of Canada, which says you can contract to limit your liability to the Employment Standards Act. I once did a quick survey of the Employment Standards Act to see how many provisions you actually had to know to truly understand what the termination provisions of the Employment Standards Act. And I think I got to about 65 sections. So it is completely ridiculous to think that the average schmo in the street who signs an agreement which says your entitlements are limited to the Employment Standards Act would have any clue whatsoever what that is. In fact, employers don't either. So what you really have is parties agreeing to follow a statute that neither of them really understands what it is. Why not? It's true. The definition of wages, the 12-week rule, the $2.5 million. There's a lot of stuff you need to know to actually understand that. So we have a world where parties apparently agree on something that they have no clue as to. The alternative is use plain English language to explain to the person what they're getting without any reference to a statute. That's how I drafted stuff 25 years ago. I didn't refer to the Employment Standards Act. I said, this is what you're getting. And make sure that it's at least the ESA. God forbid, offer a little bit more than the ESA. And remember, if you had a small company with a payroll of less than $2.5 million and the employee was there 30 years, the Act says you have to give them 8 weeks. Like, come on, give me a break. Because the common law is so different than the Employment Standards Act, the courts are going to bend over backwards. We also know 99% of employees have no negotiating power at all.
Right.
So, yes, it is sometimes like looking at, how many angels can dance on the end of a pin? Then don't be on the pin. I never, ever.
Get off the dance floor.
When I was counsel for employers, and I did a lot of it, I would refuse to do an ESA-only contract. I say, why bother? Just give them a little bit more. Just give them a little bit more. How many times, Stuart, have you seen where someone's got a clause, and then even on the termination, they offer them a little bit more? They don't even bother to try to enforce their own contracts. So my answer to Waksdale is it keeps us all in business. But the more reasonable termination provision is, the more likely a court's going to enforce it anyways.
I think about your point, Barry, from the different perspective, which is that, the people who are writing these contracts are often general counsel, in-house counsel, generalists. Maybe they have some employment employment law experience, maybe they don't. But, when there are 65 provisions under the ESA, any one of which should you contravene will void your entire section. Mm-hmm. And the difference in the outcome is 8 weeks pay versus as much as 24 months compensation, inclusive of bonus and commissions. Why wouldn't you use the right tool for the job, right? Like asking your family doctor to do neurosurgery. Sure, you can do that. But, don't be surprised with the outcome, right? If you want an enforceable agreement, maybe you need to speak to an employment lawyer in the first place. The other thing I think, and Stuart, I'd love to hear your thoughts on this, is I still don't understand for the life of me, why the government hasn't stepped in and just codified this, right? This is what people get paid, and, now we don't have to do, I don't know how many hundreds of trials there are every year for wrongful dismissal. And, the claims under employment would be limited to the more serious claims, employer bad faith, employee breach of duty of loyalty.
I wrote a paper about this about 20 years ago.
I've read it. Yeah, I remember.
Completely ignored. I came up with a proposal.
I read it.
Okay, good. One person. I came up with a proposal whereby there would be what I call the standard contract, the standard termination provision, which would be more than the ESA, and allow the parties to contract out of that, but require, if you want to contract out of it, they had to specify how it differed. In other words, there would be a template, a statutory template for maybe a month, a year or something. It didn't really matter what the formula was. And then allow people to contract out of it, thereby preserving the right to negotiate, but requiring the parties, if they did contract out of the template, to specify what the differences were, so that the employee would know, the template says I get a month, a year, and these guys only want to pay me 2 weeks. At least I know. My point is that people are signing contracts that they have no clue what it means. They don't know. So how can you agreed to employment standards, you gave up your common law right. My common law right to what? They don't know what they gave up.
But that ties into courts' refusal to use the termination provisions, which are void, to determine the intentions of the party, right? So in a lot of contractual disputes, they'll look at a contract which for some technical reason isn't valid, to determine what the parties sort of intended. But they don't do that in employment law, right?
Well, but
right.
Most commercial contracts, non-employment contracts, are there's not a lot of statutes here. Remember that this difference between what the parties intended and this argument about ambiguity. Ambiguity is a different argument than illegality, okay? Ambiguity is when there's two different ways of interpreting a clause, then we favor the employee. That's what Wood and Dealey says. Illegality is not an ambiguity, and people get that mixed up. Illegal is illegal. Ambiguous is two legal interpretations and you have to choose which one to prefer. So it's important not to get those two terms mixed up.
Yeah. No, I agree with you. I think, the illegality, like my point was just straining to find potential scenarios. Take the scenario where you've got a mom and pop shop operating a corner store.
Yeah.
And the court says, well, in theory, this guy could have been entitled to severance pay, so it's a breach of the act.
My favorite one was a guy who was a construction worker, but in the future he might not be, so therefore the clause didn't apply.
I remember that. It's a great scenario. But I mean, Chris, back to your question, like, why not codify this, which I think a lot of people have said. But then when you sit down to think about it, because I've had these discussions with people, so I'm not a big fan of just using length of service, because I do think that other factors like age and the nature of the job are relevant. So then all of a sudden it's no longer just a straight multiplier, it's some sort of a chart, and it gets really complicated. So smarter people than I am probably could figure it out, but it's not going to be as easy as it sounds. And I think that's why we are still dealing with this common law situation over and above the statute. But I agree with something, Barry, you either said today or I've heard you say it in the past, that the statute could easily be changed to be a lot more generous. So not just being the week per year, it could be 2 weeks or even a month per year. And then, the common law is over and above that in certain scenarios if you don't have a contract.
I think the reason why there will never be an Employment Standards Act that reflects real common law, because employers would freak out. No matter how many cases you say we see in court, 99% of people don't do anything about it. So employers would rather take the risk. If employers had to pay reasonable notice to everybody, it would cost them a fortune. They're much better off relying on the act, and the times when they screw it up, they pay. So what? We get a couple hundred we get maybe a couple hundred cases a year in terms of going to courts, maybe thousands that we all deal with, but tens of thousands of people are fired. Most people still will not pursue their legal remedies, so employers would freak out. We're running out of time, or at least I am. Can I talk a little bit about what I understand was happening in the Supreme Court of Canada?
Enough about me. How do you feel about me? Go ahead, Barry.
Oh no, because I've gained some new information too. So.
Oh, okay, please.
The township has sought leave to appeal Supreme Court of Canada.
Oh.
The public, when the lawyer was interviewed, he said the township was very upset with the result, so they've instructed me to appeal, which leads me to believe there's still no legal argument. But anyways, I heard that they have hired a well-known Toronto law firm to assist them, so presumably not at $2.97 an hour. And what I heard from a reliable source, sounding like a journalist, is that one of their grounds for appeal is going to be that the Court of Appeal should have agreed to a 5-person panel, and the failure to agree to a 5-person panel prevented them from arguing Waksdale was wrong. It's kind of a unique argument. So presumably they're going to.
They didn't get their day in court, right?
They didn't get their day in court. So the error was not agreeing to a 5-person judge. Now, presumably if they win that, it would go back to the Court of Appeal of Ontario with a 5-panel court, who will then probably say the first 3 guys were right.
There was a case. I want to say it was Honda v. Keys, where at the final appeal, the appellant's lawyer was able to convince the court that Wallace damages should no longer be awarded and that damages should be separately determined. I think it was Oral Cherniak made that argument.
No, I think the issue is that Wallace damages are not an extension of the notice period. They're a standalone award of damages not related to the notice period, because it was inherently unfair that if a secretary was abused and a vice president was abused, then the vice president got more for his abuse.
Right, but that turned a lot of cases on their head.
I thought it was a great decision because, as Barry said, it was silly to extend the notice period. This is a separate head of damages, and the court also made it very clear that there had to be some evidence of loss or damage beyond the usual upset that you have when you lose your job. So I thought that was a good decision, and it was kind of cool for me because I got to be at the Supreme Court of Canada in a very minor role. I was on for the intervener, the HRPA. Probably the most important thing I did was I actually helped Earl Cherniak put his tabs on in the dressing room before the hearing. And the entire time that he was standing at the lectern making his submissions, I was sitting there terrified that his tabs would come off and he'd turn around and blame me for it.
Well, I wish I'd been there because that case, when it came out, I thought was fascinating. It changed the practice significantly. And I'm wondering if there's, if they do get leave to appeal at the Supreme Court, I'm wondering if there's some room to revisit, some of the things we've talked about today, right? Whether, it's too hard to write a provision, whether, insisting on technical compliance with a provision that has, an act that has 65 provisions you could inadvertently trip over. The fact that neither party seems to be overly familiar with the act when they're entering into these agreements. The lack of negotiating power on the part of the employee. There's a lot of moving pieces here. I actually think, it would be nice for this. I actually think it would be nice for the Supreme Court to give some clarity. If this is how we're doing it going.
If you think that when the Supreme Court makes a decision, it gives clarity.
Well,
I think sometimes they take something and just make it more confusing. I think the odds of the Supremes listening are slim. A, because they don't really like employment cases. They'd rather hear the 14th
yeah, that's true.
case. And secondly, certainly on the Waksdale issue itself, just cause versus willful misconduct, that is a uniquely Ontario issue. And the criteria in the court of, as I understand it, the criteria has to be of national importance, and this is strictly Ontario. No other jurisdiction has a distinction between just cause and our willful misconduct.
All right. Well, there we go. That's a great place, I think, to wrap it up. Sarah, if you want to. Oh, it's me. Sorry, I screwed up. So we're going to bring this episode to an end. 4 minutes before Barry has to leave us. That concludes today's discussion. I want to thank our panel for the great conversation, Sarah for keeping us on track, our listeners for tuning in. If you like the episode, please subscribe, leave a review. If you have a case you'd like for us to discuss, or if you'd like to share your own story of workplace drama, email us at watercoolerjustice, all one word, @gmail.com. Until the next time,